Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California, here in San Diego. You're now watching the 5th video in a multi-part series dealing with conspiracy law. In the first video, I gave you an overview and a roadmap where we're headed. Since then, we've discussed Pinkerton liability and the elements of the crime. And last week, we focused on prejudicial joinder, meaning trying two or more defendants together in one trial. And then we chatted about Bruton case, a Supreme Court case that held that it is improper in violation of the Confrontation Clause of the 6th Amendment to use out-of-court confession of one co-defendant against another, because the defendant has a right to cross-examine any adverse witnesses. Now, this week we're expanding on the topic, and it almost seems like the Supreme Court is reversing itself. It tells us that it's okay to use out-of-court statements by a co-defendant, but let's see what the differences are between Bruton and the case this week. Thank you for joining me once again in discussing conspiracy law. We're now expanding on the topic of prejudicial joinder, meaning trying two or more defendants together in one trial. This week, we're discussing Tennessee v. Street, a 1985 Supreme Court case. There, the respondent was tried separately for the murder of Mr. Tester. So immediately, if you watched part 4 of this series, you will say, well, this is different than Bruton, right? We have a respondent who's tried separately. There's 2 trials, one against Mr. Street, and later I will tell you, one against Mr. Peel. So what's the problem? In Bruton, we said that the confession cannot be used against the co-defendant because there's Confrontation Clause issues. But here, the respondent testifies. He actually takes stand at trial, and he says that he did not burglarize nor participate in the murder of Mr. Tester. He maintains that his confession was coerced because the sheriff read to him Mr. Peel's, his co-defendant's statement, and directed him to say the same thing. If you've noticed, he's saying that his statement, his confession, is coerced. I have videos on this channel dealing with coerced confessions. Many of my clients, and I watch people online, often say that the officers did not read me my rights, my Miranda rights, the right to remain silent, that anything can be used against me in the court of law, and so on, as though that's the gold standard. But remember, even before the Miranda case, the Supreme Court long held that any confession, any statements have to be sought without coercion, and they have to be voluntary. So that's always the starting point. So if you're an attorney, or if you're watching this video in your own case, the first question before Miranda is really, is the confession voluntary and sought without coercion? And here, Mr. Street says that he was coerced. Interestingly enough, here's what the court does. The court allows the confession by Mr. Peel, or his statements, to be read out loud by the witness, the sheriff, who took the confession, to the jury. Why? Because the court says we need to compare. That's the only way. If he says that it was coerced because his statement is exactly the same as Mr. Peel's, well, let's take a look. Are they the same? Because if you read them, turns out that they're different. So his allegations that these are 2 similar or exactly the same confessions is not true. If the jury looks at the statement by Mr. Street versus the statement by Mr. Peel, they're different. There are material differences. Here's what the court instructs the jury before making the sheriff read the confession. I instruct you that such can be considered by you for rebuttable purpose only, and that you are not to consider the truthfulness of the statement in any way whatsoever. In fact, the district court read to the jury this instruction twice. But we said in Bruton that the instruction, the limiting instruction, is not enough. Remember last week I told you that in Bruton the court tells us that just because you instruct someone, it doesn't mean that they can evaluate it properly. We can't say, well, use the instruction for only one purpose. Disregard it for the truthfulness. Don't think that this confession has anything to do with Mr. Bruton last week, or in this situation with Mr. Street. But somehow the Supreme Court here says that that's okay. And here I wrote Bruton, Sixth Amendment, Confrontation Clause. Is that a violation? The Supreme Court says it is not. What's the difference? Well, the difference is that we're using the confession by Mr. Peel for non-hearsay purpose. We're not saying that what Mr. Peel said was true. He's not in this trial, so we can't cross-examine him, but that's okay. We're not saying that his confession is the truth. What we're trying to do here is evaluate Mr. Street's claim that he was coerced. And if you look at two statements, turns out he wasn't coerced, or at least that's what the jury found. And for that purpose, the Supreme Court says that's okay. It's okay to use out-of-court confessions for the purpose of rebuttal. Confrontation Clause mission itself is to advance the accuracy of truth-determining process in trial. The Supreme Court says the only way for us to figure out whether Mr. Street was actually coerced the way he's saying is to compare the two statements. And so that's the difference. In Bruton, we were using out-of-court statements for the truth, and here to rebut Mr. Street's claim. If you enjoyed this video, if you're enjoying this series, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.